So I will get right to business. I'm introducing first Mr. Lee Cutforth. He's the Alberta property rights advocate in Alberta. Lee is from Lethbridge. He's been over 25 years a lawyer in Lethbridge. He was born there. He's part of a farming family near Claresholm, and he's fourth generation Southern Alberta. His Bachelor of Science degree, undergraduate degree, is from the U of L. He did his law degree at the University of Saskatchewan. He's practiced law in a variety of disciplines in Southern Alberta. And he even served as a customs officer on the Montana border. I'm sure he has some stories from that. He's also helped in the City of Lethbridge on a Subdivision and Development Appeal Board and a variety of other public service jobs. And he's written a number of things, but one of the ones that I want to learn about tonight is, quote, what lawyers can learn from Little League Baseball. Mr. Lee Cutforth.
Well, thank you, Professor Morton. Just in case I forget later at the end of the talk, I can share the most important thing lawyers or anyone else can learn from Little League Baseball is that the other side can always win. This office, the Property Rights Advocate Office, was established in response really to an intense property rights debate and public discussion that took place about 3 years ago now, before the last provincial election, and one of the government's responses was to create this office. It was in my position as an order and council appointment. I have a 3-year term, so in a sense I serve at the pleasure of the government, but at the same time we have an operational independence so that the work we do while we're administratively within the Department of Justice, we do not really answer or give account to DOJ for the answers we give or the recommendations we make. One of the challenges of this office, with it being a new concept, we're still the only one of its kind in Canada, and in the context of the political talking points that were flying about during our rollout about 14 months ago, one of the problems was in managing the expectations of what we can do. I said at the time that I was in a real dilemma being the first advocate and being caught in some political crossfire, because I said one side of the debate wanted to paint me as a sainted miracle worker who came out of the wilderness with a bag of pixie dust that could solve all the problems. And the other side thought I was a political whore and I couldn't get a job as a grief counselor. Mercifully, we have moved through the talking points for the most part. But the fact is we do have a limited toolbox. We do not have any adjudicative or investigative powers, and we cannot immediately fix what many people might perceive to be wrong with the law or give them a remedy if the law is applied unfairly. What we can do could be distilled down to two basic functions: information and recommendations for reform. Now, in our role as a dispenser of information, I am gratified to see a piece like ALI's Guide to Property Rights in Alberta, where the intent is really to state not what we may wish the law to be, but rather simply what the law is. What the law is, warts and all, and even ambiguities and all. An example of an ambiguity, I would look at Section 19 and 19.1 of the Alberta Land Stewardship Act. And I think we can all acknowledge that, you know, the intent certainly is to improve what was there before, to take a case where there may have been no compensation available to landowners who were affected by planning decisions and provide for it. But I think there's a lingering uncertainty really over who can comprehensively expect compensation by the wording of that law. And the property rights guide that Eran and his colleague David have put together refer to a circular definition. And I think that circular reasoning that, you know, is a bit of a weakness can really give ample room for judicial meddling or judicial mischief. And as haunted as I am by the reasoning of the U.S. Supreme Court in the Kelo decision out of Connecticut about 10 or 12 years ago, and I know, you know, it is 10 or 12 years old, but I think it serves as an object reminder, because the lesson for me out of that case is that I never want to underestimate the capacity of the courts to misapply statutory intent. And certainly I would prefer to leave as little as possible, especially in taking cases, as little as possible to judicial interpretation and discretion. So I hope that through conferences like this, through publications like the work that Eran and David have done, I hope that property rights information becomes more broadly distributed, and that through that we develop an increased sensitivity to property rights. Much as we have gained a collective sensitivity to human rights over the past 3 decades, I hope we develop the same sensitivity and responsiveness to the idea of property rights. But in any event, while our office may not be able to fix things for landowners in the short term, I believe that the longer-term value of the Property Rights Advocate Office, at least within the current toolbox we have, is in the law reform function, where as a part of my annual report, I can make any recommendations regarding property rights that I deem appropriate. Now, in the report that I filed last year, it was a short report because I was appointed in December, and really I was operational for 7 days in 2012. But under the peculiar wording of the Act, and in something that can only happen in government, I still had to file an annual report based on 7 days of work. So it was understandably light on activities, but we did set out some principles on property rights and made one recommendation dealing with beneficiary deeds, which are an estate planning tool of use to landowners. And as right now, I am working on the 2013 report, which will contain 5 recommendations. But the gist of this office, I think, is that by giving public voice to landowner concerns and by bringing recommendations to the attention of the elected legislators, I hope that increased sensitivity to property rights will continue to grow and will be reflected in government policy in the future. So I thank you for your attention, and we'll turn it over back to Ted or David. Sorry, Eran.
Thank you, Lee. It's now my privilege to introduce Dr. Ran Kaplanski. Dr. Kaplinsky is a professor of law at the University of Alberta. He's been here since 2007. Prior to that, he did his undergraduate, his Bachelor of Law degrees at Tel Aviv University, and he is a Master of Laws from, and a PhD from the University of Toronto. So we have that in common, David. Dr. Kaplinsky has also been a visiting professor at the University of Toronto, at Ryerson University, at University of Sherbrooke. He's also done work in Tel Aviv in the area of municipal law and City Region Studies Center there. So he is the co-author of the new Property Rights Handbook. We've spent a lot of time on the board of the Alberta Land Institute reading earlier drafts of this. I think this is a wonderful, it's going to be a very useful contribution to the ongoing discussion of property rights and the development of property rights policy in our province. So, Dr. Kaplanski.
Thanks, Ted, for the kind introduction. I'm very pleased to be here. It's been a really great day, and I've learned a lot, very stimulating stuff, which I'm sure I'll take for future thought. And I'd like to thank ALI for publishing our guide. I'm a member of this organization called the International Academic Association on Planning Law and Property Rights. And I can tell you that property rights is a live issue in any country, from Estonia to Kazakhstan to you name it. But during the last provincial elections, it became quite clear just how strongly Albertans feel about property rights. And I was particularly struck by the expectations that were voiced during that public debate, if you can call that a debate, and further by how far those expectations were off compared to what the law says property rights are. If you've managed to take a look at your guide, then you'll see on page 5 there's a quote there from the 2012 Alberta Property Rights Task Force. And there's one line, you'll see the block quote, and the second paragraph has one line that says it all. We don't even know what we mean by property rights. So when ALI presented us with this perfect opportunity, we set out to write a guide, a plain language guide to property rights in Alberta. And these are the two questions that we tried to address. Our guide had to do two things, or take a particular form. First of all, it had to be written in plain language, with as little jargon as possible to be accessible by every citizen, every stakeholder, every agency, every organization, to give them at least a starting point, something to go by. And second, we limited ourselves to the descriptive. We have opinions. We even have strong opinions, not necessarily the same opinions, but they were kept out of this guide. We focused on trying to describe as plainly as possible what the law is. Now, the guide consists of 3 parts. Part 1 deals with property rights in Alberta generally. The second one characterizes and explains what takings of property are. And the third part deals with property rights in recent legislation. I'm not going to go through all of this guide right here. Property is a complex issue. Some of you who might be trained in law, and so you'll find my presentation a bit simplistic, but others have no formal training, and I'm hoping that they find this useful. But it's too complex, obviously, to explain in 10 minutes or so. And also, my dean really wouldn't like it if I try to teach property right here outside the law school. So I'm going to go through some highlights of the report for you, and we can cover the rest in Q&A if necessary. So first of all, property rights are determined by property law, and the law is a social construct. It exists to serve social needs. Society defines what the law is and defines what property rights are. And in our country, property rights are defined and redefined by the common law, which is developed by the courts over centuries, as well as by statute. And we are, of course, we have a Charter of Rights and Freedoms that we adopted in the 80s, but it does not include the right to private property. Rather, we go with the principle of parliamentary sovereignty, which allows governments to regulate and even to take private property, all pursuant to valid legislation. As long as the body that passed the legislation was competent to pass it, the legislation applies, and property rights may be impaired even seriously. The final point is this: if a government takes private property from the owner, then that owner is not entitled to compensation unless the owner can point to a statute that authorizes the compensation. In other words, in Canada, all compensation claims are statutory. They're not constitutional. They don't derive from a fundamental principle of justice or the common law or equity. They must be statutory. And now, in order to determine whether you're entitled to compensation, you have to look at the statute that authorizes the government action. Of course, if the government acted without authority, you can go to the courts, and the courts will confine governments within its statutory authority. But if the action is authorized, then we look at the statute and find out what it says. If it says you're entitled to compensation in accordance with these guidelines, then that's what you get. Anything that is not mentioned there, you're not entitled to. However, if the statute is entirely silent on the issue of compensation, and then the courts will presume that the legislature intended compensation to be paid. It's a presumption in our legal system that the government did not intend for the property of the Crown's subject to be taken without compensation. However, that principle, that presumption, can be overridden if the government reveals its intent clearly through the statute. And so we have statutes in our legal system in Alberta and in other Canadian provinces that say there will be no compensation here, and that is legal within the Canadian system. It may not be legal in another legal system, but it is legal in Canada. Part number 2 deals with takings of property, and it's quite easy to summarize. Generally speaking, whenever your title is taken, all of it or in parts, the fee simple or an easement or a lease or any other interest in property, expropriation legislation authorizes compensation. However, when your property is merely regulated without any taking of an interest in the property, without the government acquiring the interest, there is no compensation. There's one exception, and that is that drastic regulation may amount to de facto expropriation. That means that the owner can go to the court and say, what was done to me is so severe that the court should regard it properly as expropriation under the statute. And that remains a theoretical possibility. However, the threshold that is established by the courts, particularly in a case from the 90s by the Supreme Court called CPR and Vancouver, the threshold is very high and in fact has not been reached yet. It's very rare, in other words, that regulation will result in compensation. The third part of our guide, and I should mention we deal with property above and below the surface, given that this is Alberta. Subsurface resource rights are extremely important, and we deal with them separately. Part number 3, property and recent legislation. And this is, of course, in response to the recent legislative initiatives that have sparked the controversy over property rights. And we begin part 3 with a short review of planning legislation in Alberta, and we show that Alberta has a long tradition of legislation that affects resource rights, and that includes local as well as provincial regulations, including land use regulations. And we then proceed in the guide to review some of the recent legislation, in particular the Alberta Land Stewardship Act. And we show that by and large, this statute is entirely consistent with previous legislation. There's nothing really new about it, at least in terms of affecting property rights. Of course, it's new in its aims. Lee referred earlier to Section 19. This is a section that authorizes compensation in 3 cases, together with Section 19.1. One is where another statute authorizes compensation. Well, we can set that one aside. The other is for compensable taking, and Lee pointed out, as we did, that the definition in the statute remains a bit problematic, and I'm sure that the government will consider in the future taking a look at least at this definition. And the third is for conservation directives, where a regional plan sets land aside for conservation purposes. The owner is entitled to bring a claim as if title was actually taken, as if expropriation had occurred. Now compare this to what we heard earlier this morning. The Ontario Greenbelt Act also has a section called Section 19, and it says something very different. It says, go away. You are never entitled to compensation. You cannot appear before a court and make any claim whatsoever. In this respect, at least, ALSA is more generous relative to what the common law establishes. It's more relative to statutes elsewhere in Canada. So I will leave it to you to read the guide. I hope that you find it useful. I hope that you will circulate it as broadly and extensively as you can and refer people to it. We would welcome any comments. We regard this as a plain language guide to property rights version 1.0. As I started, property is defined and redefined by law. It's a dynamic concept. With legislation and case law evolving, we will have to make some changes, and we've already started to take a look at some initiatives, including maintaining a website that will provide the information in a more dynamic form. So let me end on that note, and I'm sure we'll have some questions and discussions. Thanks very much.
Are these mics working? Yes. Thank you, Eran. I've warned Eran that I'm going to abuse the privilege of being the moderator to make a comment on his paper. We've actually had an ongoing discussion probably over the last 12 months. As you can tell, there's some concern about the wording of the amended wording of Section 19 of the Land Stewardship Act. And the key to understanding this is the difference between government expropriating land, that is taking the title to government. That's a clear taking, and I think Alberta measures up as well as any other province on that. On land use planning, that's not likely to arise. The issue under land use planning is what's called a regulatory taking or a constructive taking. In other words, where the government's not coming and taking the title of land away from the landowner. Rather, the government is placing a restriction on land use, which may in turn reduce the value, the commercial value, the financial value of that land. So that's called a regulatory taking or a constructive taking. Now, as Eran properly pointed out, Division 3 of the Land Stewardship Act, which talks about conservation directives, I think it's fair to say breaks new ground in Canada with respect to providing very explicit right to compensation for a regulatory taking under a regional plan that's done under something called a conservation directive. And a conservation directive would sort of be like a conservation easement, which most of you are familiar with. It was discussed. But conservation easements are voluntary, right? The landowner agrees to put a conservation easement on future use. A conservation directive is not voluntary. It's the government saying, for conservation reasons, we're going to put restrictions on future use. But that's where we clearly and explicitly, in I think it's sections 35 to 39, provide this explicit right to compensation. The question is, and it was raised a lot in the public debate after the passage of the Land Stewardship Act in 2009 and the amendments passed in 2011, was whether or not a negative impact on current use land value that occurred under a regional plan, not under a conservation directive per se, but under the broader regional plan, was that also compensable? And if you look at the rewriting of Section 19, the amendments that were made in 2011, the intent appears to be to extend that right to compensation that's already granted for conservation easements to regional plans more generally. But as Eran and his colleague have pointed out, the subsequent wording that's used in those amendments appears to be quite circular. It refers to the status quo in law and equity, and as Eran points out, in law and equity, there is no right to compensation right now. So there's a problem in the wording. I would suggest that this is not the time or place to argue over competing legal interpretations, although I just have. And I'm happy to concede that this may have been poorly drafted, because by that time I wasn't the minister anymore, like I was at finance. But I wouldn't be happy if this ends up in court and the narrower interpretation is given, because certainly it was my understanding as a member of government and as a member of cabinet at that time that the purpose of the Section 19 amendments was for this broader right to compensation. So I would recommend, and now that I'm not in government, I have the right to freedom of speech again, that that the minister responsible be proactive on this issue. I think he should consult with the lawyers, the government lawyers, and maybe with other officials in SRD, and make a statement that this was, if he agrees with me, that this was not the interpretation that was intended by the government at the time. And I would recommend that the government proceed to administer and enforce Section 19 according to the broader interpretation that does give the right to compensation. And then if need be, maybe introduce a future amendment that makes it clear that that's the purpose. But if it simply acts in accordance with what I understand to be the spirit of the Section 19 amendments, it need not even go to a court. And as Lee said, the hazards of judicial interpretation or judicial misinterpretation. So those are my 2 bits worth, and Eran, I believe, would like to comment. And then we'll go right to questions.
No, I think we could go right to questions. As you said, this is not, we're not going to parse the wording of the language. If we all had the statutes in front of us, then...
I've consulted a number of lawyers, and several have said that Eran's interpretation is very compelling and plausible and could very easily be adopted by the courts. But I've talked to other lawyers who've suggested that, well, there may be this alternative explanation. I'd like to see the government clarify this. So, floor is open to questions.
My question isn't necessarily related.
Please, all the speakers should identify themselves.
Ron Axelson.
Yeah, I know Ron,
Yeah.
but nobody else does.
Well, thank God. My question is maybe more of a history lesson. Why wasn't property rights enshrined in the Charter of Rights? And now that it becomes a regulatory issue, as suggested. And what is the, looking at, say, the Western world, what is the, is property rights part of constitutional law in other Western, I'm just kind of curious about this. It seems like this is quite different than, and I can remember the debate way back in, I think it was in the 80s when this was going on. And I think the answer was, even Premier Lougheed says, you know, there are times when the government needs to do things that people won't necessarily like when it comes to property. So I'm just kind of curious, as you know, a bit of a history lesson behind this.
You have 2 professors up here, so you're going to get 2 answers. But Eran gets to go first.
There are 2 explanations that have been offered, and I'm sure different people have different versions. Sorry. Can you hear me now? All right. So I'm sure different people might have different versions of the historical events, but there are 2 explanations that are widely recognized for the absence of property rights from the Charter. The first was a lack of desire to have the courts engage in what is known as substantive due process review. That is, to look into the merits of particular government programs and to say you should do this, you should not do that. And the other explanation is based in the division of powers in the Canadian Constitution, which reserves jurisdiction over property and civil matters in the province to the provinces. So why make property a national issue?
I would just add that at one point, both Premier Lougheed and Premier Bennett of British Columbia said they wanted property rights in. As Eran just said, it was strongly opposed by Quebec and also all the 3 of the 4 Atlantic provinces. New Brunswick, PEI, and Nova Scotia almost all have restrictions on foreign ownership of shoreline because they don't want Americans owning the whole shoreline there. And they're worried that that might be subject to a challenge under a property rights provision. And again, if you go back to 1981, you remember it wasn't just the property rights issue, excuse me, it wasn't just the Charter of Rights that was on the table, it was the whole national energy program. And again, some of you recall that Premier Lougheed, Saskatchewan, Alberta, and BC extracted a number of concessions from Trudeau under natural resource management, what's now called Section 92A of the Constitution. So there was a lot of bargaining back and forth at that point. And basically, I'd say Lougheed, because he got natural resource recognition of provincial natural resource ownership and also the notwithstanding clause as a guard against, turned out not to be much of a guard, but a safeguard against judicial misinterpretation of the charter, he thought that was enough, and so he signed on to a charter that didn't have property rights in it, and as I said, there were Quebec and Atlantic provinces were certainly opposed to that. I would simply add, though, and Eran could do a 60-second example, property rights is, of course, explicitly named in the U.S. Bill of Rights, and yet the most recent decisions the court has refused to extend the right to compensation to landowners who suffer a regulatory taking, in other words, a loss of value as a result of a land use regulation. So even having it in the Constitution wouldn't, I don't think, by itself have solved or addressed this issue of regulatory taking.
Well, if we're going to compare the law to the United States has the Fifth Amendment to its Constitution, which requires that takings be for a public use and subject to compensation. And that's quite clear. And when land is taken, that's no different than our expropriation laws. But over a century ago, a case was decided by the Supreme Court that also recognized the right to compensation for regulatory takings. Now, when does regulation amount to a taking under U.S. law? Well, Justice Holmes, who penned that decision, had a very useful test. I'll know it when I see it. So regulation gone too far is a taking. But since that case, there have been two exceptions where regulation amounts to a per se taking. It's automatically compensable. And the first one is the denial of all economically viable uses. So whenever you wipe out the owner economically, you must compensate. That is not the law in Canada. For a taking to occur in Canada, all private uses have to be removed. So as long as you can go horseback riding on your property or pitch a tent there, you haven't been expropriated, even if you cannot build anything.
Harvey Buckley, according to the last question, that what you just discussed, there was quite an article in the Calgary Herald on the weekend on that very issue of the property rights and the constitutional issue. And according to that article, which was written by the gentleman that also wrote the book on stealth, if you recall what that was, I believe his last name was Milke, M-L-I-K-E or something. But anyway, at any rate, was saying that just Trudeau, the Prime Minister at the time, only had the support of Bennett to put property rights in the Constitution. So whether he's accurate or not, I don't know. However, my question is, and I haven't had a chance to read this, but it looks great. It's simple and very understandable, but at the bottom of page 24, where you're talking about ALSA, and ALSA is allowing for compensation, or shall we say, addressing the question of compensation. Has the Institute given any thought to expanding that, and I don't know if it's in here or not, but into ecological goods and services? Because it seems like this whole field of ecological goods and services, we're just starting to get our minds around it and starting to discuss it and starting to understand that, yes, it does have a value, and yes, it is part of the property. Is there any thought given at all to including that as part of the value of the property?
When you say value, what do you mean? So including it in what context? So you talked about expanding this project, but can you explain your question?
In what context, you're saying?
Yes. So,
Well, actually, you know, most of us that are landowners, I'm a landowner, I consider the ecological goods and services as part of the land that it supplies. But as those services, and part of those services are supplying, for instance, the watershed, into the watershed. In my instance, when I live in Calgary's watershed, I am supplying the water to the city of Calgary. Now, it does have a value, but I guess what I'm asking is it going to be included in property rights as part of the value of the property? And I'm very interested in that because personally, we have just finished a year or so ago just putting part of our ranch under a conservation easement. And I think that it does have some value. That's my view. But because we did an ecological assessment as well, which places a value on your ecological values. But I'm just asking whether you're including that. And of course, when you include that, it may be a challenge to express to people so they get their minds around what property rights really mean and what does my property right entitle me to. If you go this one step into the Ecological Services, of course, maybe you need a separate publication or something because you'll complicate what you've already made understandable. So if that explains to you where I'm coming from, I'm just trying to establish, is there a value, or do you feel there will be a merit in establishing a value? Because it seems like in the future we're going to be wrestling with this.
well, certainly ALI is very active in the area of ecological goods and services. In terms of monetary value, if you're talking about compensation and regulatory effects, generally the amount of compensation is always determined by changes in the market value, what land might realize on the open market, willing buyer, willing seller kind of thing. That's the measure of land values in the legal system. I hope that answers the question.
I'll throw in 2 bits worth here. I'd be surprised if any of us on the panel were not in favor of a program which set up some sort of regime where landowners were compensated for providing environmental goods and services, whether it's habitat, riparian integrity, other types of air, water, land, or wildlife, ecological goods and benefits. What I think Eran just said, though, is that you're not going to be able to go to a court and argue that, well, I, Harvey Buckley, am already providing these ecological goods and services, but damn it, I'm not getting paid for it. So start paying me. I don't think that's going to wash. That's going to require a government program. I would point out that Division 4 of the Land Stewardship Act makes provisions for precisely those types of offsets, tradable development credits, all of those types of programs. So the statutory architecture is there for the government to go forward with an EGS compensation program, but it will require new legislation.
Bob DeMulder. Question is more of, I did have a glance and look at this thing, and I think this issue of property rights tends to have a fairly good connection in the rural community as opposed to the urban community. And it seems there's always this manifestation of what the Americans' view of property rights are. And just as a suggestion in time is maybe a compendium on this that says what's the difference between the Canadian Alberta example versus the American example, because I do see a lot of the American view come up that says it is part of the Constitution, and that's where it seems to perpetuate. So just as a comment.
Thank you.
Hi there, I'm Laura Taylor. I'm the girl from Toronto. Not sure if I'm the only one here, but it actually kind of allows me to ask this question. So in my years as a consulting planner, I worked a lot at the urban-rural fringe when, due to regional planning, the decision was made to expand the urban area of whatever settlement area you were in into the rural area, and that made people very rich. So the landowners made off like bandits, some of them, as their land value changed because of planning. And so where's that side to this? This is, you can use it as a theoretical question, but this idea that regional planning takes away some of your future commercial rights to be able to do something with your land, shouldn't you also then pay the government when you get commercial rights due to regional planning?
Now, is this only the people who have just been approved for new development, or all existing homeowners get to pay too for their previous benefit?
Well, it's the same. It's very, to me, it's very similar with this idea that for a landowner has regional planning that says that we're going to use part of your land for conservation, and that landowner is questioning whether or not they have the right to ask the government to pay for that loss. Am I understanding that correctly? Okay.
Right.
So therefore, when a very similar landowner, due to regional planning, all of a sudden is now allowed to, all of a sudden, 20 years of a planning process, is allowed to build row houses on their land. And it's not an agricultural value, it's a commercial value. They can build residential homes and they make a lot of money off that. So shouldn't the money then go back to the state because of what the state did? There's no give and take to this, and this is what's always bothered me with the way it's talked about in the States, as though, you own the land. You don't own the land, you're not here for that long. So I realized that you said the opinions weren't in the document, and I get that, so I'm allowed to talk about my opinions here.
Do you want to take a crack at it first?
Whether you make money or lose money off of land use regulation is a crapshoot. Basically, lots of people in Alberta and every other province and every U.S. state and probably everywhere in the world, people who owned agricultural land on the fringe of fast-growing municipal or urban areas made money as that land, as the city expanded, and that land went from agricultural use to industrial or residential use. And of course, as then plans are brought in and restrictions are placed on it, the expectation or the benefit that had been being realized by the landowners is reduced. And it's a roll of the dice, it's a crapshoot as to when that happens and where the line is drawn. Are you inside or outside the line that's going to go to, I think the idea of telling landowners they'd have to give money back from profits realized through subdivision is wouldn't work here.
Why should I as a taxpayer then? Why should I as a taxpayer pay the landowner?
Because
that's the part that
okay,
I need more information
let's cut right to the chase. In Rocky View County right now, and Foothills. Well, I was the MLA for Foothills and Rocky View. Right now, most landowners who may be reaching retirement age cannot sell their properties, cannot sell land. Why? Because it's too expensive for agricultural use, and nobody's going to buy it for non-agricultural use because of the uncertainty of what's going to happen under the regional plan and under the Calgary Regional Partnership. In other words, there's no question that the combination of the Land Stewardship Act combined with the prospect of a Calgary Regional Plan is reducing the market value right now of people of landowners in Foothills, Rocky View, and in Foothills and Rocky View counties, okay? And while this does not address the Municipal Government Act, in which, as I think there are a lot of municipal councilors here, under which you can take reserve land and also environmental land without any compensation. That raises an interesting contrast to what's proposed under the Land Stewardship Act. But under the Land Stewardship Act, we're saying that you do have a right to compensation. And the example I'd give right now is there's a lot of discussion, both federally and in the province, about reducing public sector pensions, right? Actually, look what's happening down in Detroit, a big reduction. And on the one hand, lots of people say, well, these pension plans are way too rich, they can't be afforded. The people that are paying for them, the kids paying for these pension plans that were promised by politicians that aren't there anymore, they have to be reduced. But everybody realizes that if you've worked for the city of Detroit or any other, or the province of Alberta or any other province for 20, 30 years to build up that pension, you can't just, it's unfair to take it away. And in Alberta, maybe we're a little closer, I suppose we are closer to our rural and agricultural background. Most of us realize that, you know, I sleep at home, I go to work in the office, and my retirement plan is an RSP at the bank. But a rancher or a farmer, he lives on his land, or the family lives on the land, their office is on the land, and for a lot of them, the retirement is on the land as well. And I think that understanding is quite widely shared amongst Albertans, and so I think that's why we see it as, well, the caucus that I was part of, as yeah, we could do what Ontario said and say, so long, goodbye, too bad, but we didn't. And we put in the conservation directives initially, and then we tried to expand that in the 2012 amendments, but as Eran has pointed out, the wording is circular, and that may need to be addressed.
If I can add to that, certainly there are proposals. For example, the Lincoln Institute for Land Policy has been advocating, at least considering the idea of land value taxation. There are other proposals out there and some experience with betterment taxes. Think, for example, about the contributions of landowners adjacent to the Shepherd subway line to contribute, you know, to the cost of the line given the increase in their land values. Most countries that have tried to levy betterment taxes have had a very poor experience with this. In the United States, I believe New Hampshire is the only one, or maybe one of the two, that tried it and didn't like it very much. But you know, since you've invited me to profess opinions, I'm happy to do that, and I can make the case for compensation generally. The first one is a fairness argument. That is, you said this morning, we're all in this together. But the landowner says, if we're all in this together, how come I'm the only one who gets stuck with the bill? And the second argument for compensation is an efficiency argument. Because the government says there is a lot of value in the conservation that we create. But what is this value? I can tell you what the value of my family minivan is because I signed the check. But when the government says it is well worth conserving this land because the benefits of conservation exceed the costs, it's cheap talk unless the government is actually willing to pay. If the government says, look, I'm willing to pay the $2 million and we're still better off, that is the best proof that regulation creates net benefits as opposed to net costs. Without compensation, the values are all theoretical.
So we'll move on to the next question.
Hi, it's Marian Weber. And I guess this kind of follows up on your comment, but I have this perception that in Canada we have very nice, lofty statements, policy goals related to environment and conservation. But I think that on implementation we're weak, especially when it comes down to the bylaws and the regulations. And I've had this idea that maybe the stronger interpretation of property rights and takings in the US potentially takes a lot of the issues around implementation into an economic domain and out of a political domain and actually makes it easier. And I wonder if you have some thoughts about that.
Could you restate the question just one more, give it maybe slightly different?
So do you think that having stronger property rights interpretation in the US actually makes it easier in some ways to implement environmental regulations because it's less political?
Well, I'm not sure. I mean, only at the margin.
I was going to say, I don't think it's fair to say across the board that property rights, that this type of property rights protection, in other words, the regulatory taking, is stronger in the U.S. By my reading, there are about 4 or 5 states where it may be, but there are 50 states, right? I think if what you're getting at is something as a deeper point, which I think we may agree on, and that is my understanding that the first, let's call it the first generation of the environmental movement, in a certain sense, defined landowners as the enemy, certainly in the West. And I think there was a realization that the command and control, telling people what they can't and cannot do, led to the shoot, shovel, and shut up syndrome that we're familiar with. And it seems to me that, let's call it the next generation of conservation initiatives is evolving towards a premise that to be successful, conservation issues have to see landowners as partners, and there need to be recognition of the kind of environmental goods and services that Harvey Buckley mentioned earlier. And that's certainly where I'd like to see Alberta go, that landowners see the land use planning, maybe on some, there'll be some negative parts of it, putting restrictions on land use. We'll see what the compensation may or may not be under that. But if that's balanced with or partnered with an environmental goods and services program, which is something certainly the Alberta Land Institute is looking at under Vic's leadership, I think that would be kind of the other side of the coin in modern, in contemporary Alberta land use policy. And that would be a very clear economic benefit to landowners, because suddenly, I guess this is the topic of tomorrow morning's session, right? If it pays, it stays. Isn't that tomorrow morning's session? And a recognition that that offering the carrots that the speaker from California spoke of earlier may be a more effective way to do the conservation most of us in the room would like to see happen, more carrots and fewer sticks. And that would be the flip side of the coin, or part of what I think would be a full package of land use policy.
I might be taking this in a totally different direction. Well, I know I am. When we're talking about property rights, I'm wanting to ask a question relative to the Crown's right. Given the earlier session was talking about wetland policy, we have under the Public Lands Act, in the statute, it lays out that all water-covered areas are deemed to be Crown land. And an issue for me is that I've recently seen a significant wetland that was there as long as I've known it, over 50 years, drained, and the compensation monies were turned over to Ducks Limited to take it over. The question I have for the panel, and I don't know if this is the place to ask it, is as far as I understand, it's an administrative procedure for the Crown to go ahead and look at that property and determine whether it's ephemeral or permanent, and whether the Crown has an ownership right or it doesn't. And if the Crown does have an ownership right, from what I understand, that requires a particular order in council in order for that property right to be turned over, but I don't see it. I just see wetlands being drained that have been there since Christ was a child, as far as I'm concerned, and the Crown is claiming no right but to go ahead and bend over and see the money go over to DU. And with a wetland policy coming into play here, I'm just wondering, what right does a Crown have for these wetland areas?
I don't think I have much to contribute beyond what you've just said. If it's permanent and naturally occurring, then it belongs to the Crown. If it's not, then it does not belong to the Crown.
Are you aware of any guidelines? So then your question is, on a permanent and naturally occurring wetland, if it's drained for development, and then, yes, there's an offset paid to a third party, in this case Ducks Unlimited, fine, but legally speaking, what the heck happened to the Crown ownership? When I was minister, that's why I had assistant deputy ministers like you to answer those questions.